Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, every now and then you come upon a ruling, you know it's completely ridiculous, and then you have to stop and think like, oh God, could this spread like a bad cancer? And when it comes to arguments in favor of civilian disarmament, we will see that no matter how dumb, how ridiculous, how stupid an argument is, if it can be used to justify a piece of civilian disarmament legislation, well, it will start popping up all over the place. I'm going to share with you a ruling that came out of the state of Colorado by a judge who candidly needs to retire, because I do think that it has the potential, well, to spread like cancer. So today, let's get you all educated and talk about what if the Second Amendment didn't protect gun sales? Okay, coming to you from Washington's nicest indoor shooting facility, of course, that's Security Gun Club, right here in Woodinville, Washington. We're talking about the case today of Rocky Mountain Gun Owners v. Polis. Now, for those of you who have been following what's going on, the state of Colorado recently passed new civilian disarmament legislation, what they call gun control legislation, which included a mandatory 3-day waiting period before anyone can take receipt of a firearm which they were otherwise lawfully allowed to own and possess. Now, of course, the lawsuits have started flying, and one of the things that happens when we have a lawsuit challenging a new law as unconstitutional is we ask for an injunction. That is, we ask for the court to hit a big fat pause button so we can figure out the merits of the argument so that citizens are not otherwise subjected to unconstitutional laws. The court here has denied that motion for an injunction. Now, it's the reasoning for which they denied that has me concerned and will probably have all of you concerned if we start seeing this line of reasoning pop up everywhere else. You see, the Honorable John L. Kane, all 86 years old, appointed to the federal bench by Jimmy Carter. So can you imagine that anything from the Carter administration is actually still kicking around in this country? But His Honor has ruled that while the Second Amendment may protect the right to keep and bear arms, it does not protect the right to acquire a firearm. It does not protect the right to accumulate firearms. It does not protect the right to purchase a firearm. Now, true to the historical analogs that we asked courts to take a look at, His Honor went back and found an old dictionary and began the reasoning for this decision as follows. Plaintiffs contend that the words keep and bear in the Second Amendment are implicated by the waiting period required by this act. In Heller, the Supreme Court examined the normal meaning of those words at the time of the nation's founding, reviewing definitions from contemporaneous dictionaries. As the court explained, the 1773 edition of Samuel Johnson's Dictionary of the English Language defined keep as most relevantly to retain, not to lose, and to have in custody. The court then turned to the word bear and determined it means to carry. The court clarified that when bear is used with arms, however, that term has a meaning that refers to carrying for a particular purpose, confrontation. And then, of course, connecting the dots, the court ruled. So, putting all the pieces together, the court found that the text of the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. From this reading of the plain text, it is clear the relevant conduct impacted by the waiting period, the receipt of a paid-for firearm without delay, is not covered. Still, plaintiffs attempt to equate the words obtain and possess, but these terms are not equivalent. To keep, under the definitions provided in Heller, meant to retain an object one already possessed. It did not mean to receive a newly paid-for item, and it certainly did not mean to receive that item without delay. Likewise, having weapons indicates the weapons are already in one's possession, not that one is receiving them. So, under this line of reasoning, since we don't have a constitutional right to accumulate a firearm, the danger is that in some of your incredibly blue, very pro-civilian disarmament states, what's to stop them from establishing a 30-day waiting period, a 60-day waiting period, a 180-day waiting period, a 3-year waiting period? What's there to establish some kind of a licensing fee in excess of $5,000 before you can take possession of the firearm? How about you just require that you come up with at least 12 character letters demonstrating that you are in fact suitable to be owning that particular firearm? Because you see, if the Second Amendment did not protect the ability to acquire a firearm for self-defense, then none of those activities would in fact be in violation of the Constitution. And as His Honor put it, I mean, candidly, why should people have quick access to firearms? They probably didn't way back at the time of our nation's founding. As the court specifically stated, even if commercial sales of a firearm are protected by the Second Amendment language, Colorado's waiting period is likely to withstand constitutional scrutiny because there were no Guns R Us outlets at the time the Second Amendment was ratified. And so the moral of the story is that when we thought last summer after the Bruin opinion came out that all of the ridiculous shenanigans, all of the ridiculous and ludicrous reasoning would finally come to an end with the announcement of the very clear one-part test in Bruin, what we have seen is greater creativity and greater intellectual dishonesty from those who wear black robes that are hell-bent on civilian disarmament. If this ruling were to spread, if this reasoning were to become acceptable, you may have a right to possess and keep a firearm, but you will never ever have a right to accumulate one. Consider that plus all of the other laws and crackdowns that are being made on personally made, privately made, or unserialized firearms, and you can see how there is a full frontal attack on every direction in order to obtain civilian disarmament. The case, once again, is Rocky Mountain Gun Owners v. Polis. We will link it up down below so that you can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information is also down there in the description box. Now, in the meantime, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.